Three quarters.
I ain't gonna say that. He'd say I said. He told me to do something.
All right. 34 out session on the baby that way inside. He's driving in the moment silence. You can have a seat. Mr. Chairman, I understand the screen jury's ready. They are. We all clear that area there just for a second.
I don't know. Are we okay here, Your Honor? You want us to move?
You're fine. All right, for the grand jury. Everybody be seated, please. Thank you. Who's the foreperson of the grand jury? Mr. Foreman, have y'all completed your work today?
Sorry.
Have you completed your work
Yes,
today?
sir.
Have 9 or more of you agreed?
Yes, sir.
Mr. Bailiff, will you cover report? Sheriff? Thank you, Sheriff. Everything appears to be in order, ladies and gentlemen. I've initiated the process to either have summons or warrants issued to carry out the service to get these people in front of the court. If they're already in custody, we'll probably do a summons. If not, we'll do a warrant. But in any event, it's very important that you keep confidential everything you did back there, okay? It's part of your duty. So I guess the next time that you come in will be on September the 24th. So you can be excused. All rise for the grand jury. Y'all go out this way. Thank you. Thank you all for your service today. Okay, let's call some transported folks. Louis Arms, Cumberland versus Louis Arms. When it gets to be 2:30, tell me so you are Louis Arms?
Yes, sir.
Good morning. We're here on 21 CR 0058, 21 CR 00137 for probation revocation and a pretrial conference on 26 CR 0045. Were you born? Were you born in 1964?
Yes, sir.
Last four digits, social security number 8381.
Yes, sir.
What does the Commonwealth have to say about
We
this?
have felony plea.
Motion's been tendered, Mr. Arms, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
This is plea freely and voluntarily given. Are you the same person that we just identified in open court in 3 cases?
Yes, sir.
Is your judgment impaired today in any way?
Yes, sir.
Is your judgment impaired today? You know what's going on? You know what impaired
Yes,
means?
sir.
Yeah.
You're trying to pick-
Have you discussed the charges with your attorney? Are you satisfied with his advice?
Yeah.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You know, you don't have to enter a guilty plea today. You have certain rights in the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over them. If any time have any questions, step away from the podium and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove beyond a reason without your guilty charge against you. Understand it by entering a guilty plea today. You give up those charges. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait a pre-sentence investigation report done by probation and parole. In the event I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea. You understand that?
Yes,
Mr. Stockton, what is the Commonwealth's recommendation?
Mr. Arms will plead guilty to possession of controlled substance first degree, receive a sentence of 3 years, probated for 5 years. In lieu of revocation in 21 CR 58 and 137, he agrees to extend the probation 5 years on those cases beginning on this date. He will agree to enroll and complete a long-term rehabilitation center. He'll pay court costs at discretion of court, and all evidence in this case will be destroyed.
Is that your understanding of the Commonwealth's recommendation? Are you pleading guilty because you committed acts charged in the indictment as a matter of fact? Doing so of your own free will. Right. Knowing your constitutional rights, explain to us still your desire to give up those rights to plead, enter guilty plea and allow the court to fix your punishment. You understand that after entering this plea of guilty, any future conviction could be enhanced in the persistent felony offender law. You understand that?
Yes, sir.
Is that your signature on the document?
Yes, sir.
Order a pre-sentence investigation report and have sentencing. You know,
Would the court consider sentencing him today? He has been in for quite some time.
I have to have a
He is
pre-sentence
currently
investigation
supervised.
report. I can't wait pre-sentence investigation.
Awesome.
You know,
Yeah, whatever the court wants to do, we'll have to do. I don't have any objection. He's not a state prisoner. I don't know how you can waive sentence.
do what?
He's not a state prisoner, so I don't know how you can waive sentence.
No. Well, where, is he going into a rehab?
Yes.
I tell you what I will do. If you can get him a bed date in a rehab, I'll change his bond condition. And then schedule the sentencing. For date we schedule. You understand what I'm saying?
Yes, sir. I will work on that.
You know, I've known Louis for a long time. He's a frequent flyer, Louis. You know, get straightened out, but he just got addiction problems. So we always seems to stand up and take responsibility for what he does. I appreciate that. So if you can get him a bed date, I'll change his bond condition, okay? Heather Edens. Heather Edens. Are you Heather Edens?
Yes, sir.
Get behind the podium there if you would. Good morning. You born in 1973,
Yes, sir.
last four digits, social security number 5720.
Yes, sir.
We're on 26 CR 0038 for a pretrial conference. What we have.
Your Honor, we're still waiting on the gunshot residue kit. We'll call on that and tell them that's really, I think, all we're waiting on. I know Mr. Sheffitt's got some things to do after we get the results, so I don't know when you want to reset it.
Yeah, I don't know what kind of timing we're looking at.
If you want to set it for next month, I can give you an update on the testing.
We'll do a review on September 24th. There's no reason to set a negotiation date now. Okay. Okay. Commonwealth versus Tia Hancock. Tia Hancock. Commonwealth versus Tia Hancock, 26 CR 0056 for the purpose of arraignment. 20 CR 0025 for probation revocation. Are you Tia Hancock?
Yes, sir.
Good morning. You were born in 1992.
Yes.
Last four digits, social security number 2575. What does the Commonwealth have to say?
Yeah, we have a plea,
Felony plea?
felony probated.
Okay. A motion has been tendered, ma'am, that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
The same person we just identified in 20 CR 0025 and 26 CR 0056. Are you impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
You believe you're fully informed about your case?
Yes, sir.
Now, you have certain rights under Kentucky and the United States Constitution. Before I can accept a plea today, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt you're guilty of charge against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I'll look at the pre-sentence investigation report done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that? Mr. Hundley, what is the Commonwealth's recommendation?
Your Honor, upon a plea of guilty to tampering with physical evidence and possession of a controlled substance, first, second degree, second offense, the defendant shall receive a sentence of 3 years on each charge to run concurrently for a total of 3 years, probated for 3 years, probation to be supervised. In lieu of revocation in Cumberland Circuit Court Case Number 20 CR 00025, the defendant agrees to have her probation period extended for an additional 3 years beginning on this date. And unusually, the defendant shall not receive any credit for time served. Defendant shall pay court cost at the discretion of the court, and any drug paraphernalia or contraband shall be disposed of in accordance with the laws of the Commonwealth.
All right, technically, we have not arraigned her yet, so I need to go ahead and do that. The grand jury of Cumberland County has returned an indictment charging you possession of controlled substance in first degree, tampering with physical evidence, wanton endangerment in a second degree, possession of drug paraphernalia, and being a persistent felony offender as far as the tampering with the evidence. Mr. Bale, you acknowledge that any client received indictment, waive formal reading and arraignment, and is she ready to enter a plea?
Yes, Judge.
Okay. Ma'am, you heard what the Commonwealth's recommendation is. Is that your understanding? Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes,
Are you doing so of your own free will?
sir.
Knowing your constitutional rights, explain to us still your desire to give up those rights to enter a plea of guilty.
Sir.
Now you understand that this plea could make any future convictions enhanced. You're already a convicted felon and you could have had a PFO this time, but you can get any more. It could be enhanced. You understand that? That's your signature on the document.
Yes, sir.
Now, is she to go into a rehab or anything? What's the story here?
I don't see anything here,
So are you
other
probated?
than it's to be supervised.
Okay. Well, I'll go ahead and set a pre-sentence investigation. What was the agreement that she stay in jail till she's sentenced?
Yes, I was.
That's typical. Okay, so it will be on September the 24th, or a pre-sentence investigation report was sent on September 24th. Dustin Hayes. Commonwealth of Kentucky versus Dustin Hayes, 26 CR 0037. Are you Dustin Hayes? Good morning. We're here for sentencing today. Were you born in 1986?
Yes, sir.
Last four digits of social security number is 7836. Could you give me the pre-sentence investigation? Have you had an opportunity to look at the pre-sentence investigation report number probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counsel, is there any reason this gentleman should not be sentenced today?
Okay.
I'll plead guilty of possession of controlled substance, first degree, second offense, and shall receive 3 years probation for 3 years probation to be supervised. He shall enroll and complete a long-term rehab center. Sentence to run consecutively to 21 CR 00138. The court cost
$220.
$220, and we'll take care of that at you'll need to make some payments. I'll let you pay that at $25 a month, first payment, done 30 days after you complete the long-term rehab. Now, you need to find a bed date for him.
We got a bed for him at Spark for the 31st.
Okay, so are they gonna transport your Spark?
That on the transport, I'll submit an order.
Submit an order and let him out on that day, okay? Thank you very much.
Thank
you. Eva Nethery. Commonwealth versus Eva Nethery, 26 CR 0052. You Eva Nethery?
Yes, sir.
Were you born in 1960?
Yes, sir.
Last four digits, social security number 0743.
Yes, sir.
You're here today on a pretrial conference. Do you have a plea agreement?
We do have a plea agreement for the court to consider, Judge.
It's a felony plea.
Okay. Motion's been tendered, says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes, sir.
The same person named in indictment number 26 CR 0052. Is your judgment prepared in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
You believe that you've been fully informed about your
Yes,
case?
sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. I'm gonna go over those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering guilty plea today, you give up those rights. You understand that? I may consider the Commonwealth's recommendation, but I'm applying range since provided law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation for probation parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose partial sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Your Honor, Ms. Nethery would plead guilty to operating a vehicle under the influence. She would receive a fine of $200. Also, she would plead guilty to 2 counts of wanton endangerment. They will be run consecutively for a total of 10 years. She'll be probated for 5 years supervised. However, she'll have to enter and complete a long-term treatment facility scheduled through DPA, and that would be done after sentencing, and she would stay in custody until then.
Is that what you agreed to? Okay. Are you pleading guilty because you did commit the acts charged in the indictment? Knowing constitutional rights explained to us, it's still your desire to give up those rights in her plea and allow the court to fix your punishment. You understand that after any guilty plea on the DUI, it's enhanceable. If you get another DUI, it's enhanceable. It'll be more. And also the felony pleas are enhanceable. You understand that? Under persistent penalty, is that your signature? Okay, I'll accept the plea agreement order, pre-sentence investigation board, and schedule sentencing for September the 24th. Thank you.
Thank you.
Cumberland versus Austin New. Morning. Cumberland versus Austin New, 26 CR 0039, 24 CR 0032, 24 CR 0033. Are you Austin New? Born in 1986.
Yes, sir.
Last four digits, social security number 8510.
Yes, sir.
Okay. You're here today for sentencing. Have you had an opportunity to review the pre-sentence investigation board done with probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason that Mr. New should not be sentenced today?
No, Your Honor. And for the record, we had received a copy of the risk assessment, sex offender risk assessment. We went through that, didn't note any issues.
Mr. Stockton, in Mr. New's case, are there any victims' statements?
No, I told Mr. Carr that, the young lady was going right one and she started, but couldn't get through it, so she didn't submit them.
Mr. New, you've entered a plea of guilty, probably to the most heinous crimes I've ever seen anybody accused of since I've been practicing law here. I absolutely don't understand how one human being, a father in the most trusted position, can do something like you've done. I do not understand it. But you have accepted responsibility for what you've done. And I think the sentences that you have indicate the seriousness with which the Commonwealth takes the charges against you. Upon a plea of guilty in indictment number 24 CR 0033 for the charge of possession of a controlled substance, methamphetamine, he shall receive a sentence of 3 years, which shall run concurrently with the following sentences. Upon a plea of guilty under indictment 26 CR 0039 of incest, counts 1 through 7, the defendant shall receive a sentence of 20 years on each charge to run concurrently for a total of 20 years. Upon a plea of guilty to the charge of incest on counts 8 through 14, the defendant will receive a sentence of 10 years on each count to run concurrently for a total of 10 years. For the charge of incest, the 20-year sentence and the 10-year sentence shall run consecutively for a total of 30 years. Upon a plea of guilty to indictment number 26 CR 0039 for a charge of sodomy, 3rd degree, count 1 through 4, the defendant shall receive 5 years on each count to run consecutively for a total of 20 years. Upon a plea of guilty to sodomy, 3rd degree, counts 5 through 14, the defendant shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. For the charge of sodomy, 3rd degree, the 20 years sentence and the 5-year sentence shall run concurrently for a total of 20 years. Upon a plea of guilty, indictment number 26 CR 0039 to a charge of rape, 3rd degree, counts 1 through 4, you shall receive 5 years on each count to run consecutively for a total of 20 years. Upon a plea of guilty to rape, 3rd degree, counts 5 through 14, the defendant shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. For the charge of rape, 3rd degree, the 20-year sentence and the 5-year sentence shall run concurrently for a total of 20 years. Upon a plea of guilty to indictment number 26 CR 0039 for a charge of possessing or reviewing a matter portraying a sexual performance by a minor, counts 1 through 4, the defendant shall receive a sentence of 5 years on each count to run consecutively for a total of 20 years. Upon a plea of guilty of possession or reviewing a matter portraying a sexual performance by a minor, Counts 5 through 13, the defendant shall receive a sentence of 5 years on each count to run concurrently for 5 years for a charge of possession of matter portraying a sexual performance by a minor. The defendant shall receive 20 years and the 5-year sentence which will run concurrently for 20 years. On a plea of guilty and indictment number 26CR0039 for a charge of promoting a sexual performance by a minor, counts 1 through 3, the defendant shall receive a sentence of 10 years on each count to run consecutively for a total of 30 years. Upon a plea of guilty to promoting a sexual performance by a minor, counts 4 through 13, the defendant shall receive a sentence of 10 years on each count to run concurrently for a total of 10 years. For the charge of promoting a sexual performance by a minor, the 30-year sentence and the 10-year sentence shall run concurrently for a total of 30 years. The 2 30-year sentences and the 2 20-year sentences shall run concurrently for a total of 30 years. In the 3-year sentence in indictment number 24CR0033 and the 30-year sentence in 26CR0033 shall run concurrently for a total of 30 years. The defendant shall receive credit for time served. The defendant shall forfeit any and all evidence to above style case and shall be destroyed in a manner consistent with the laws of the Commonwealth of Kentucky. I will, considering the length of the sentence, I will waive the court calls.
Thank you, Your Honor. Just a couple of things, Your Honor, if I may approach, if there's just acknowledgement to be registered, and then we dismiss the original indictment. All right. That's all we have, Your Honor.
Okay, I will sign the sexual offender acknowledgement to register. William Trent Owsley. Are you William Trent Owsley?
Yes, Judge.
Good morning. This is 24CR0010. Were you born in 1993? Last 4 digits, social security number 4996. You're here on a pretrial diversion revocation. What's the comment to say?
Your Honor, Mr. Owsley has a possession case, 3 years. He had some problems while he was on probation, so we put him into specialty court. He had problems in specialty court. He agreed to start over. And after he started over in specialty court, he was positive for alcohol and opiates, and he was terminated. So I'm asking the court to revoke his diversion.
Judge, we would stipulate that he was terminated from special.
Well, I will void the pretrial diversion, request a pre-sentencing investigation report, and have sentencing on September the 24th. Marquia Vibert. Are you Marquia Vibert?
Yes, sir.
This is 26CR0043. Good morning.
Good morning.
Were you born in 1995?
Yes.
Last 4 digits of your social security number are 4120.
Yes, sir.
You're here today on a pretrial conference. What does the Commonwealth have to say?
Pretrial diversion, please.
Motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that is named in 26CR0043?
Yes, sir.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes.
You understand that you do not have to plead guilty, that you have certain rights in the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over them. If anytime you have any question, you can step away from the podium, talk to the attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor. right to appeal this matter to higher court. If you lose, the right to inquire the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand?
Yes,
That
sir.
by entering a plea of guilty today, give up those rights. You understand that?
Yes, sir.
I'm gonna consider the Commonwealth's recommendation to amend applying range of sentence provided by law. If I don't accept the recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea. Now, I'm gonna ask you some qualifying questions. Have you been previously diverted in the last 5 years?
No,
Had any felony convictions in the last 10 years?
no, sir.
Are you currently on probation or parole?
No, sir.
You understand if you successfully complete the diversion program, charges will be dismissed pre-trial diversion, you can have your record expunged. You understand that?
Yes, sir.
You understand if you do not complete the diversion program successfully, you'd be brought back in front of me and I can void your pre-trial diversion, and you have a sentence and you'd be a convicted felon.
Yes,
That
sir.
could be used against you in the future, you understand that? Mr. Hunley, exactly what is a Commonwealth's recommendation?
Someone pleaded guilty to possession of a controlled substance, namely first degree, namely methamphetamine, and complicity to tampering with physical evidence. The defendant shall receive a sentence of 5 years on each charge to run concurrently for a total of 5 years. She shall serve 30 days, be balanced, pre-trial diverted for 5 years. Terms of the diversion are that she is to be supervised and receive credit for time served. And the defendant shall receive and enter and complete the Cumberland County Specialty Program. The defendant shall be released at orientation. Again, as part of her diversion, she shall obtain gainful employment or do a minimum of 30 hours per week community service until gainful employment is obtained. Any evidence in contraband acquired in this case shall be disposed of in accordance with the laws of the Commonwealth.
That's a 5 year session.
Just be 3 years.
That's correct.
That need to be it.
It's for probation, it's 3 years.
Does that need to be changed on the document?
We can't do that.
Let's just interlineate while we got the document.
She got the tanker too. Well, she got the tanker for physical evidence, that's a 5 year sentence, so we can go for.
Okay,
Yes.
That was the way, I forgot about the tanker.
okay. Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Does anyone, including your attorney, offered you anything else in return for your plea?
No, sir.
You plea because you did commit the act of charge.
Yes, sir.
No, your constitutional rights explained to us to your desire to give up those rights and plead guilty to the charge and allow the court to fix your punishment.
Yes, sir.
That's your signature on the document.
Yes.
I'll accept the agreement to sign the diversion. And when is orientation, you know? Has she been voted in yet?
She would vote in this morning, I don't know.
Well, congratulations. So they'll do the orientation. You really got a chance to turn some things around for you. I hope you take advantage of it. Okay.
Thank you. Court costs
Court costs $215, and I'll allow you to, when you get a job, you need to notify them. We'll start letting her pay you $30 a month. Getting a job is part of your drug court experience. Okay. Thank you. Now, we've got a Clinton County case here. It says on the document, Jeremy Shepherd. Is that correct, Mr. Stockton?
Yes, Your Honor.
Jeremy Shepherd. It's in the arraignment. You have the document there.
I have,
Well, I'll just ask you if you received it.
I have a plea agreement, but I don't know that I have the arraignment,
But y'all give me a copy of the indictment.
Yeah.
Commonwealth of Kentucky versus Jeremy Shepherd, Clinton County Circuit Court, case number 25 CR 00109. Did y'all get that for me there? Thank you. You are Jeremy Shepherd, is that correct?
Yes, Your
Good
Honor.
morning. You were born in 1983.
Yes, Your Honor.
Last four digits, social security number 9078.
Yes, Your Honor.
I'm gonna do an arraignment. The grand jury of Clinton County has charged you with flagrant non-support. You understand what that charge is?
Yes, Your Honor.
You acknowledge the identity of your client and you have in your possession a copy of the indictment. Is that correct?
I do acknowledge his identity. I know
Is
the
it
charge.
not acknowledge, accept, interplea of not guilty, waiving all pretrial motions?
Yes, Judge.
Reserving all pretrial. I said, wait, reserving all pretrial motions. When do you want to set this for a negotiation?
We have a plea for the court to consider.
Okay, is it a diversion or?
It's a diversion. His family paid a substantial amount on the child support. So
Okay, a motion has been tendered and says you wish to interplea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea free and voluntarily given?
Yes, Your Honor.
Are you the same person that we just named in Clinton Circuit Court Case 25 CR 00109?
Yes, Your Honor.
Is your judgment impaired today?
No, Your Honor.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, Your Honor.
You believe you've been fully informed about the case. You understand that you do not have to enter a guilty plea today.
Yes, Your
You
Honor.
have rights under the Kentucky United States Constitution. Before I accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial with jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor of process issue, compel your attendance, right to appeal this matter in higher court if you lose, and right to have the Commonwealth prove beyond reasonable doubt if you're guilty charged against you by entering a plea today, you give up those charges. Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentence, but I have no law. In the event I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of trial. I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, Your Honor.
Has any felonies in the last 10 years?
No, Your
Are
Honor.
you currently on probation?
No, Your Honor.
You understand if you successfully complete the diversion programs and meet your obligations, the charge will be dismissed and you can have your record expunged. You understand that?
Yes, Your Honor.
You understand if you do not successfully complete the diversion program, then you'd be brought back in front of me, I would revoke the pretrial diversion, and you'll be a convicted felon, and that could be used against you in other felony cases. You understand that? What is the Commonwealth's recommendation?
Your Honor, Mr. Shepherd will plead guilty to flagrant non-support. He'll receive a sentence of 5 years. Brett Balance pretrial diverted for 5 years supervised. He'll get credit for time served. He'll pay his normal monthly obligation of $445 a month and an additional $200 a month, so the arrearage can be paid within the diversion period for a total of $645. The first payment will be due 45 days from release, and each month thereafter, he'll obtain and maintain gainful employment, and the diversion will be supervised. He'll be released today, Your Honor.
So what you agreed to?
Yes, Your Honor.
What did it cost?
I think what girl.
You know. What did you say?
What did you say?
$155 court costs. I'll allow you to pay that, an additional $30 a month on this other obligation you have. Give you a little space on it, okay?
Yes, Your Honor.
Okay.
He'll have to go, since it's Clinton County case, Mr. Garner will tell him he'll have to go up to Wayne County probation.
Can you go over there today?
It's, he's go up there. and
Okay, well,
back.
as soon as you are you going back to Clinton County
Yes,
Jail?
sir.
You get released there, you go from there straight to probation and parole officer to meet with probation and parole officer over in Wayne County.
Yes,
Okay?
Yes,
I'm
Your
gonna trust you to go there.
Yes, Your Honor.
Okay? Thank you very much.
Thank you.
Good job, Your Honor.
Good.
Thank you so much.
Yeah. Combo versus Danny Allen. Are you Danny Allen?
Yes, sir.
Good morning. You have an attorney?
Morning, sir. Yes, sir.
This is 26 CR 0055. Mr. Allen, you were born in 1960.
Yes, sir.
Last four digits, your social security number 2430.
Yes.
Here the purpose for arraignment, you have a right to remain silent. The grand jury of Cumberland County's returned an indictment. charging you with possession of controlled substance of first degree. Possession of controlled substance not in the original container. And failure to signal. You understand what those charges are? Good. Counsel, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, interplead not guilty, reserving all pretrial motion.
Yes, Judge.
Sir, I'm signing a reciprocal discovery order that require the Commonwealth to give your attorney certain information to help you prepare for your defense. What's the negotiation date, Mr. Stockton?
September 18th at 9 a.m.
September 18th, 9 a.m. and your next court date is September the 24th. Both of them are conditions of your bond. Okay. Since we started a little late today, do any of you defense counsel have one case or something you'd like to take if you need to move? You don't have anything?
Yes, Judge.
Yeah, what do you have?
And Joseph Bryan, Mr. Cross, not have Joe Bryan. He's. I don't think he can.
That's on at 10:30. Right?
Correct.
It's gonna be at 10:30. It's gonna be on Zoom. Does anybody have a come around? Are they present here?
I'm sorry?
Are they present here?
Yes, sir.
Okay. Who are they?
William Todd Outwood, Rebel Felony Plea.
William Todd Owsley. Commonwealth of Kentucky versus William Todd Owsley, 26 CR 0025. Are you William Todd Owsley?
Yes, sir.
You were born in 1966.
Yes, sir.
Last four digits, social security number 9744.
Yes, sir.
I understand that you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
This plea freely and voluntarily given?
Yes,
Are
sir.
you the same person that we just identified in 26 CR 0025?
Yes, sir.
Is your judgment impaired today? And that's right. Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
And understand that you do not have to enter a guilty plea, that you have certain rights under the Kentucky United States Constitution before I accept the plea guilty. I want to know that you fully understand those rights.
Yes, sir.
You have the right not to testify against yourself. No one can make you say anything, right to speak trial, but jury right to be represented by counsel at your jury trial. You have the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor, right to bill this matter to a higher court. If you lose, you have a right to require the Commonwealth to prove you're guilty beyond a reasonable doubt. You understand that by entering a plea today, you give up all those rights.
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentences provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I'll await a pre-sentence investigation report to be done by probation, parole, and vet. After reviewing that, I do not accept the recommendation, decide to impose a harsher sentence. You have a right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
Mr. Hunley?
Yes, Your Honor, we have a burglary, pardon me, we have a felony plea. I can get to it. On plea of guilty of burglary. Second, the defendant shall receive a sentence of 7 years. Upon plea of theft by unlawful taking of controlled substance, the defendant shall receive a sentence of 5 years. The two sentences shall run concurrently for a total of 7 years, probated for 5 years with the probation to be supervised. The defendant agrees to enter and complete the Cumberland County Specialty Court. If he's not eligible for drug court, then he shall enroll and complete in a long-term minimum of 6 months rehab. The defendant agrees to pay restitution in the amount of $295.74 to Cheryl Parmley and Keaston Parmley. Restitution is to be paid in full at final sentencing.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
Doing so of your own free will.
Yes, sir.
Your constitutional rights to explain to us it's still your desire to proceed with the plea and allow the court to fix your punishment. You understand after hearing this pleading, future convictions can be enhanced as far as your penalty law.
Yes, sir.
Is that your signature on there?
Yes, sir.
Okay, I'll accept the agreement. Reschedule or pre-sentence investigation report. Schedule sentencing on September 24th. You need to meet with probation parole officer right there. You got another one?
Yes, sir, Judge. I've got Shane Bonsi.
Commonwealth versus Shane Bonsi, 26 CR 0041. You are Shane Bonsi. Good morning. You were born in 1990. Last four digits, social security number 36. So you're here for the purpose of arraignment. You have a right to remain silent. The grand jury of Cumberland County.
He's on the virtual office.
Okay, so a pretrial conference.
Yes, sir, Judge.
You have an agreement?
We don't have an agreement, Judge. We'd like one more pretrial. We're very close. We're just waiting
Yeah,
on.
I need it. We have difficulty sometimes bridging the victims. They think they were talking about, we might understand.
September the 18th would be another pretrial conference, and the next court date, September 24th, and both of them are conditions of your bond.
Thank you, Judge. You have a good day.
And to safe traveling.
Your Honor, I have three if you that are here and ready to go if you should.
Come around.
I have Barbara Parrish for second.
Commonwealth versus Barbara Parrish, 26 CR 0022. Are you Barbara Parrish?
Yes, sir.
You born in 1989.
Yes, sir.
The last four digits, social security number 0985.
Yes, sir.
You're here for sentencing with your attorney. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes, sir.
Is it substantially correct?
Yes.
Is there any reason that your client should not be sentenced today?
No, Your Honor.
Upon a plea of guilty to possession of controlled substance, meth, first degree, the defendant shall receive a sentence of 3 years, probate for 3 years. Probation is to be supervised. Court cost of what?
$220.
$220. You need some time to pay that.
Yes, sir.
I'll allow you to pay it $30 a month, first payment, 30 days from today. You'll need to meet with the probation and parole officer.
Right. April Nethery.
April Nethery. Commonwealth versus April Nethery. 25 CR 0072, 25 CR 0073, 26 CR 0011, and arraignment on 26 CR 0049. You are April Nethery.
Yes,
You're born in 1981.
Yes, sir.
Last four digits, social security number 5139.
Yes,
You have a right to remain silent. You are represented by counsel. The grand jury of Cumberland County has returned an indictment charging you with trafficking and controlled substance, first degree, second offense, possession of drug paraphernalia, and being a persistent felony offender as to the trafficking. Mr. Bailiff? Counselor, do you acknowledge the identity of your client?
I do, Your Honor.
Receive the document.
Yes, sir.
Waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir.
You have a negotiation day?
I think we've got a plea.
We did. We have a plea.
Okay,
I have the paperwork.
great. A motion's been tendered. Is that the plea?
It is, Your
Keep
Honor.
it there so she can identify our students.
Yes, sir.
Motion's been tendered, says you wish to enter a plea today. Is that correct, Ms. Nethery?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that we just identified
Yes, sir.
in these various cases. Is that correct?
Yes, sir.
If you discuss these charges with your attorney, are you satisfied with her advice?
Yes, sir.
And review the evidence Commonwealth has against you and you feel like you're fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you fully understand those rights. I'm going to go down through the rights with you. If at any point you have questions, ask your attorney, step away from the microphone. Other than that, I'll ask you to end if you understand, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial of the jury. Right to be represented by counsel at your trial. Right to confront and cross-examine all witnesses. Call to testify against you. Right to use evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to require the Commonwealth to prove no reasonable doubt you're guilty of charges against you. Understand that by hearing you plead guilty, you give up those rights. You understand that?
Yes,
I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided by law. I don't have to accept the recommendation prior to accepting the recommendation. I will await a pre-sentence investigation report to be done for probation parole. And after reviewing that, if I decide not to accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea guilty and proceed to trial. You understand that?
yes,
And
sir.
Mr. Huntley, what is the Commonwealth's recommendation?
Your Honor, upon the plea of guilty to trafficking in a controlled substance first degree in case number 25 CR 00073, the defendant shall receive a sentence of 5 years. Upon the plea of guilty to possession of a controlled substance first degree, case number 26 00011, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to trafficking in a controlled substance first degree, case number 26 CR 00049, the defendant shall receive a sentence of 5 years. The 5-year sentences in case number 25 00073 and 26 00049 shall run consecutively for a total of 10 years. The 3-year sentence in case number 25 CR 73 is to run concurrently with case number 25 73, 26, 49 for a total of 10 years to serve. She shall serve 180 days jail time with no home incarceration, and the balance shall be probated for 5 years. Probation is to be supervised. Once the defendant has completed the 180 days incarceration, she shall enter and complete a minimum of 6 months at a 6 month rehabilitation center. She shall pay court costs at discretion of the court and agrees that any drugs and paraphernalia be disposed of in accordance with the laws of the Commonwealth.
Is that what you agree to?
Yes, sir.
Are you pleading guilty?
Yes,
Because
sir.
you did commit the acts charged in the indictment as you
Yes, sir.
so your own free will. Knowing your constitutional rights, is it still your desire to enter this plea and accept the penalties that have been stated, or any other penalty within the range permitted by law? Is that your signature on the document there?
Yes, sir.
Okay. I'll accept the agreement order of pre-sentence investigation report, schedule sentencing on September 24th. You are in the custody of the jail.
Your Honor, Ms. Nethery has an afternoon, is it a dog? It's okay. Okay, never mind.
Thank you. And your third client?
Constance Cherry. She has a co-defendant, Dylan Cherry. I think you could probably call them both at the same time.
Constant Cherry and Dylan Cherry. Are you Constant Cherry,
Yes,
born in 1995?
yes.
What are the last 4 digits of your social security number?
3111.
3111. Now, we're here on 26 CR 0014. Are you Dylan Cherry?
Yes, sir.
What, you born in 1991?
Sir,
What are the last 4 digits of your social security number?
9680.
Okay, you're on here on 26 CR 0013. What's the Commonwealth have to say about these?
Your Honor, now that I'm back over, I'll ask for one more pre-trial. If it's not resolved, I'll ask for a
What
trial.
are the charges you're talking about?
Several counts of criminal abuse and also additional count of assault on Mr. Cherry.
Okay, we'll have a negotiation day on September the 18th here at 9 a.m. Next court date is September the 24th. Both of them are conditions of your bond. You all understand that?
Judge, these cases have simultaneous
civil side with the district court, juvenile court. And I think they're at the place now, with both of them out of custody, that DCBS is they're at a place where they can work a plan. I would ask the court to consider, at least if the district court allows any type of visitation or contact, I would ask this court to mirror the bond conditions. to the
If that
district court.
happens, you contact Commonwealth Attorney. Okay, and then I'll get both of you on the phone. We'll talk about it to inform you. I just don't want to make a decision in the dark without both of you being there, okay? Thank you very much.
Thank you, Your Honor. That's all I have, Mandy.
Yeah, have a safe journey. You just have one case on, or you have other cases?
I've got, if we can custody, we can take up William McIntyre now.
Well, we're gonna go down through this docket. If you're gonna be here anyway, we'll just go down through the
I've got a
docket.
couple of arguments.
What about Bryant? Did both of y'all represent Bryant? It was scheduled at 10:30 there on the act. Is that the only thing that, your co-counsel has on the docket?
Stepped out, he's primarily for the, well, whatever, we can go ahead.
We'll just go down through the docket then, okay? Andrew Beatty,
There's an active warrant, Your Honor, I'll put him in CIC.
Marshall Beatty. Commonwealth versus Marshall Beatty. 20 CR 0045. Are you Marshall Beatty?
Yes, sir, Your Honor.
Born in 1993.
Yes, Your Honor.
Last four digits, social security number 4203.
Yes, Your Honor.
For the purpose of arraignment, you have an attorney?
I do not.
Can you afford an attorney?
I cannot.
Okay, well, you'll need to do an affidavit on him, but for the purpose of arraignment until I determine your eligibility, I'm going to ask Office of Public Advocacy to step in. You have the right to remain silent. The grand jury of Cumberland County returned an indictment charging you with possession of controlled substance in the first degree, possession of controlled substance in the second degree, possession of drug paraphernalia, possession of marijuana, failure to maintain insurance, operating a motor vehicle under the influence, and improper parking, and license not in possession. You understand what those charges are?
Yes, Your Honor.
Mr. Bale, if you present with counsel, you acknowledge Mr. Beatty's identity, proceed an indictment, waive formal reading and arraignment, enter a plea of not guilty, observing all pretrial motions.
Yes, Judge.
Okay, I'm signing a reciprocal discovery order. Requires the Commonwealth to provide evidence. Mr. Stockton, I noticed this case here is a 20 case.
Yeah, he's in CIC, Your Honor. I don't know why I didn't serve. We're saying served here locally.
Turned himself in.
That's probably a good. Well, we only placed him for some reason, but it may have been our office mistake. We only put him in CIC in January this year. It's probably what we overlooked at the fees.
Okay, we got a negotiation day on the 18th. Next court appearance on the 24th.
Thank you.
Thank you, Judge.
Mr. Beatty, you need to come over here and fill this affidavit out as far as you're eligible for a public,
Yes, yes, Your Honor.
you know, with this gentleman right here.
Okay.
You just have one case on the docket?
Yes, Your Honor.
Okay, I'm gonna go ahead and let you call it. Mr. Cross, Commonwealth, we go, Adair County Jail, will you switch on there? Commonwealth of Kentucky versus Joseph Bryant, 26 CR 0062. No, 26, excuse me. Are you Joseph Bryant?
Yes, sir.
You born in 1974?
Yes, sir.
Last four digits, social security number 2971.
Yes, sir.
What do we have going on here?
Your Honor, this is the case we delayed because I made a request with the Prosecutor's Advisory Council to pay for further mediation. And that was actually approved and they've actually adopted that policy. Now we can pay for half of it. So if the court will allow, we'll enter it and y'all prepare a mediation order. We can have this mediated, and if that doesn't resolve the case, we'll get a
They
call.
decide who's the mediator, who's the mediator, Judge?
Well, I think we can pick now since AOC is not in charge of it. So I would give to Judge Patton if it's all right. Like Judge Patton, so good.
Okay,
Yes.
enter an order. Your attorney's gonna be up and talk to you. They're gonna do a mediation, Mr. Ryan, okay?
Yes, sir.
I'm gonna go ahead and call, Holly Dykes. Holly Dykes.
Go ahead.
I got that, ready to go back.
What are these things?
That's right.
Okay, I'm gonna appoint public advocacy on this. I'm looking at the affidavit, appears that she's entitled. You feel this thing for me.
Brady, will you tell Austin and Miller that Chris, I'm ready to go back?
Are you Holly Dykes?
Yes, sir.
Were you born in 1988?
Yes, sir.
4 digit social security number 0297.
Yes, sir.
Appointed office of public advocacy to represent you. Your attorney was here. You have a right to remain silent. The grand jury of Cumberland County has charged you with possession of controlled substance, first degree methamphetamine, possession of drug paraphernalia, and public intoxication. You understand those charges?
Yes, sir, I do.
Counselor, do you acknowledge the identity of your client? Receipt of this indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Judge.
Yeah, I'm gonna sign a reciprocal discovery order, ma'am, which will require the Commonwealth to provide you information, help you prepare for your defense. We'll schedule a negotiation day on the 18th of September, and the next court date's on the 24th of September. Now, what is the story on Ms. Dykes' bond?
You set her bond,
It was a surety bond. She couldn't make that one. You asked me to let you know. She couldn't make that.
How much was the surety bond?
Yeah, we've been trying to find her things out. Like,
$15,000. She stayed up, but she been on.
so I would like to be.
I can't hear you.
We've been trying to find her since August with written letters from different law enforcement agencies.
I just asked if relief to be a secured bond because I don't have to
Well,
look for
I
it.
just have it set at 15,000 clerk approved surety, and that's not a very high
She
bond.
can't make that.
Well, Tennessee residents can make it too if they present somebody to you that's a Kentucky resident.
Yeah, so
Is that sufficient bond?
I'll chance it. if she
Okay,
wants.
well, here's the thing about
I
it.
just want to get good
I'm
information on the
gonna, I'm
bond.
gonna include the condition of the bond. If someone comes forward to make the bond for her, that she sign a waiver of extradition
The bond holder.
in addition. Okay,
Thank you.
thank you very much. Your attorney will be up to see you, Ms. Dykes. Jade Jones. Commonwealth versus Jade Jones. Are you Jade Jones?
I am.
Good morning. You're here on 23 CR 0053. Ms. Jones, were you born in 2002?
Yes, sir.
Last 4 days of your social security number 7722.
Yes, sir.
You here on this 23 CR 0053 on a pretrial diversion revocation. What's the Commonwealth have to say about this?
Your Honor, she was on diversion. Her probation was transferred to Tennessee under interstate compact. We got a request from interstate compact to revoke her diversion because she got a new felony arrest in Putnam County, Tennessee. She was charged. She had a child in the car. She was passed out in the car. Since they've requested her revocation, she's entered a plea in Tennessee and it was granted 4 years probation on that Tennessee charge, and she's being supervised by Tennessee. So I think the appropriate thing to do would be to withdraw my motion to revoke and place her on unsupervised visitation. Otherwise, we're going to be putting her in jail on a case that Tennessee probated her for. And I just don't want to be whipsawed by the state of Tennessee.
What was the charge in Tennessee?
What was it, Jeremy? Was it criminal abuse or wanton endangerment?
Criminal abuse and
Neglect. And they granted her probation on that.
They granted her probation and she has to go through some steps, including completing treatment down there.
Yeah, I don't agree with what they did down there, but that's
What
not my
was
place.
the charge here that she's broke?
Possession, 3 years. So we'd be sending her to prison on possession, and they granted probation on a much more serious felony, in my opinion.
What about the extension of the probationary period?
We could, but all we're doing is she's still gonna be supervised by Tennessee, so now that she's got the 4 years supervised down there, I don't see any reason Kentucky still needs to supervise her on the possession charge.
Commonwealth is she going to jail down there or?
No, she's being probated down there. She's got a
Okay,
break.
well, Miss J. Jones, you can just mark this down as your lucky day that you have the folks down in Tennessee have been generous to you, but I would be very careful if I were you from here on out. You understand what I mean? At this time,
Yes, sir.
avoided death.
Yes,
I'll send an order up. You got somebody to pick you up?
I do.
Okay, well, we'll sign an order up there and tell somebody to go up there to get you, okay? Thank you.
Thank you so much.
Jackie, Jacob Voris. Commonwealth versus Jacob Voris. Is that how you say your last name?
Boris is fine, yes.
Voris. Mr. Voris, were you born in 1991?
Yes.
Last 4 digits, social security number 5782.
Yep.
Okay, you're here on a motion to revoke your shock probation on 16 CR 0077, 17 CR 0029, and 20 CR 0008. You're also here on a pretrial conference on 26 CR 0042. Mr. Cross is present to represent you. What does the Commonwealth have to say?
Your Honor, we'll leave this problem.
What is the charge?
He's got tampering with physical evidence and possession of a firearm by convicted felon. And I think there's also a possession of controlled substance, methamphetamine.
There is.
Probably I would elect to try the possession of a firearm by convicted felon and do a 404B on the other issues.
Okay,
You can set it out a bit, Your Honor. Whatever you've got available, we'll try to work it in.
what'd you say?
I said, if you could set it out just a bit, I know September and October are pretty big, but for me, but whatever you've got available, to try to work it out.
Well, what do you mean trying to work it out?
Try to work it into the schedule.
Okay, I thought you were trying to work.
Well,
the
we're
case
still-
out. I said,
we're
we will
still
work the
gonna talk.
case
We've
out
got some-
today and not schedule a trial.
Mr. Stockton was not at the last negotiation session, and
Yeah,
I've still got some hope, but I think we need to keep it moving and set it.
What about October 16th?
I have trials set, Your Honor, in Metcalf.
Criminal trial? What about October the 6th?
I've got some things in Wayne motion hour that day, but I could move them if we want to. That's what we want to do.
Okay, well, any motions that you have that need to be filed on September 24th through May.
Do so, Your Honor.
Okay.
Jacob, I'll be up to see you.
Adair County, is that all we have up there with you right now?
That's it.
Okay, you have a blessed day.
Thank you too.
Okay, let's go back to this docket here. Thomas Bradshaw for Raymond. Morning.
Good morning.
Commonwealth versus Thomas Bradshaw, 26 CR 0048. Mr. Bradshaw, were you born in 1961?
1964.
1964, okay, I'll change that on the docket. Last four digits are social security number 7621.
Yes, sir.
For the purpose of arraignment, you have an attorney with you?
No.
Can you afford one?
I'm sure.
I'll go ahead and point out some advocacy for you. You have a right to remain silent. Grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree. Second offense, possession of drug paraphernalia. Operating a motor vehicle under the influence in careless driving. Counselor, you acknowledge Mr. Bradshaw's identity, receipt of indictment, await formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motion.
Yes, Judge.
Mr. Bradshaw, I'm signing a reciprocal discovery agreement here. Part of the Commonwealth to provide you the information to prepare for your trial. You need to be here on September the 18th for negotiation and September the 24th. Both of them are conditions of your bond.
Sure.
Okay? Jimmy Clark says active warrant. Stephen Eves.
That's a felony.
Commonwealth versus Stephen Eves, 26 CR 0032. Are you Stephen Eves?
Yes, sir.
Good morning.
Good morning.
Were you born in 1981?
Yes, sir.
Last four digits, social security number 5393.
Yes, sir.
I understand that you wish to enter a plea today. Is that correct?
Correct.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
What was that?
Is this plea freely and voluntarily
Yes.
given? Are you the same person that we just identified in 26 CR 0032?
Yes, sir.
Is your judgment impaired today in
No,
any
sir.
way? Is your judgment impaired today in
No,
any
sir.
way? Okay, have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
You believe you're fully informed about your case. Okay, you have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty, that you're guilty of the charges against you. You understand that by entering a guilty plea today, you give up all those rights. Yes. Now, may consider the Commonwealth's recommendation, but I may apply range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will wait the pre-sentence investigation report from probation and parole. After reviewing that, if I decide not to accept their recommendation and decide to impose a harsher sentence, you have a right to withdraw the guilty and proceed to trial. You understand that? Mr. Hunley, what is the Commonwealth's recommendation?
Upon plea of guilty to trafficking in a controlled substance first degree, the defendant shall receive a sentence of 8 years to serve. Upon plea of guilty of tampering with physical evidence, the defendant shall receive a sentence of 5 years to serve. The two sentences shall run concurrently for a total of 8 years to serve. Commonwealth opposes probation and or shock probation. The defendant shall pay court costs at the discretion of the court. Any drugs or paraphernalia involved in this case shall be disposed of in accordance with the laws of the Commonwealth.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
Doing so of your own free will. Knowing your constitutional rights to explain to us is to your desire to proceed with your plea and allow the court to fix your punishment. You understand that after hearing this plea of guilty, any future convictions can be enhanced under the range of penalties. You understand that under persistent felony offender law. Is that your signature on the document?
Yes, sir.
I'll accept the plea agreement, order a pre-sentence investigation report, and schedule sentencing on the 24th of September. You are in the custody of the jailer.
Judge, would the court consider allowing him to remain out of custody? He's been out of custody since I've had him in circuit court and has been compliant with his bond.
No. Thank you, Elton. Billy Farley.
It's,
Caldwell versus Billy Farley.
I do that, one of the rest. It's a motion to revoke.
That's for warrant arrests. He's not here.
Okay. Was he served?
I love you.
Was he served? Billy Farley.
It's his last known address. Did you notify him?
I did tell him he had a 40 days and I seen him, but
What's the story on him here? Is he just?
It's odd. Go get here.
Judge, he got a driving while intoxicated charge in North Carolina. And it's still pending over there, but he was operating a commercial vehicle at the time. So that's why I requested revocation.
Yeah. I was want to try to work with him because he owes a lot of child support. He's been paying his child support. But I couldn't overlook the DUI. I had to file some probably figured that's.
He has done well up to this point.
Did you give him a date to be here?
I told him that he had a court date coming up. Every time I meet with him, I give him their next court dates.
Did you tell him the date though?
I did.
Jeez. Okay, well. We'll issue an FTA warrant on him, okay? Christian Garner. Commonwealth versus Christian Garner, 24 CR 0079. Christian Garner,
Yes, sir.
you were born in 2006.
Yes, sir.
That's 48 social security number 3014.
Yes, sir.
We're on a pre-trial diversion application. Tell me that, Mr. Stockton.
Your Honor, he's got a 5-year sentence on unlawful transactions with minor. We previously filed a motion because he wouldn't work and do community service. After that, he got a job at McDonald's. He ended up losing that job at McDonald's. He will not do community service. Officer Garner's tried to get him hooked up with the reentry employment specialist, and he will not call them. He will not return their calls. And according to Officer Garner, he just sits at home. So we can have a hearing if you want.
Well, I guess we've already heard that.
Well, I can swear somebody in and go into more detail if you want to.
Did I hear you say you had some nice things like that? But you gotta do community service, but you're not working. Like if you don't have that, maybe if there's a problem, you gotta do it. That's the job you have. What happened? Not been there for this year because I'm sick. This is what we're talking. I was starting. I was your.
So, Judge, I understand the Commonwealth's position. And Mr. Garner, I'm sure needs to do a better job of following up on some things. McDonald's sounds like that was the situation. He was let go because of absences. He was sick and it sounds like sick to the degree that he wasn't able to work, and I guess they were ready to move on.
I want to tell you what I'm gonna do. I'm not gonna revoke you today. I'm gonna put you in jail. And you'll stay in jail till the next real day as a sanction. Now, I want you to get serious about this. We do not have time to mess with you. With all the other people that Mr. Garner has to try to keep. It's his goal to help you stay out of jail and make something out of yourself and have a normal life, but you've got to help do that, man. You got to take this seriously. So you're in the custody of the jailer, and we'll see you next Monday in between now and then, okay? Joseph Grider. Joseph Grider. Does anybody know where Joseph Grider is?
Just yell for a hardship.
Hardship license hearing? Didn't show up.
I don't have a left, I mean, it's maybe.
Okay, we'll just pass over. Tina Heath, active warrant.
We'll put her in CIC.
Okay. Dwight Harold.
Oh, I'm sorry.
Commonwealth versus Dwight Harold. 22 CR 0006. You Dwight Harold? Oh, Dwight. Born in 1971.
Yes, sir.
Last four digits, social security number 4088.
Yes, sir.
You're on a probation revocation.
Your Honor, as you know, Mr. Harrell's situation, he was in a fire and was severely injured, but the problem with the Commonwealth's having with him, he admitted to the use of meth in March. He had a positive meth use in May, and he had another meth use in July. Mr. Payne is his probation officer. He's got treatment. He's been going through SAP IOP, but evidently it's not working. He's got him lined up to go to Foothills inpatient rehab, where that way he can go there and his family can take him to these doctor's appointments. But he's got to quit using the meth, otherwise I'm gonna have to ask for revocation. And that's the problem. That's not prescribed medicine. The other one was oxycodone and marijuana, but he's got
He's gonna be inpatient there.
at Foothills.
Well, I don't want to send you to jail. You have a hard time with things you got going on if you're in jail. I mean, I'm sure they try to take care of you, but you know how that goes, right? So I'm gonna allow you to go over there to Foothills. I understand what you've always been in court down through the years, but you've always been a hard worker. You're not a lazy bone in your body. And I know you're going through, but you're just gonna have to not try to self-medicate, okay? You commit to me that you try to do that. You work with him over there at that rehab?
Sure.
Okay. When does he need to turn himself in over there? Yeah. When you got a
Today.
date for him? Okay, can you be over there by 4:00 today, okay? You can go sooner than if you want to, but over there.
Judge, may I be excused, sir?
Sure. Have a great day.
Thank you, Judge.
Do I? Go ahead. I don't know who we have anymore. I guess you got a full bus.
Yes.
Okay. Commonwealth versus Logan Pickering.
You're over there, Nicole defendant on a separate number, and that's Nicole.
And Nicole Pickering. Y'all will stand over here, please. Commonwealth versus Logan Pickering, 26CR0046. Are you Logan Pickering? You born in 1987? Last four digits, social security number 4063.
Yes, sir.
Are you Nicole Pickering? You're in 26CR0047. Were you born in 1989? Last four digits, social security number 4673. You're here today for the purpose of arraignment. You have a waiver of dual representation.
Your Honor, I have a waiver of dual representation if the court require of them if they've executed this, and I think that.
You understand that Mr. Cross represents both of you. If there was any conflict or anything, he's required to report that to you and you make a decision, but up to now you waived that. Is that correct? Both of you do? Okay. The grand jury in Cumberland County, Mr. Pickering, has charged you with complicity to theft by unlawful taking over $10,000. You understand, Mr. Bailey? You understand what that charge is? You acknowledge receipt of indictment, waive formal reading, arraignment, and plead not guilty for Mr. Pickering.
Yes, Your Honor.
Covering all pretrial motions. Now, Mr. Pickering, the grand jury of Cumberland County has charged you with theft, unlawful taking, or disposition over 10,000, but less than $1 million. Here you go. What it says. Mr. Cross, you acknowledge the identity of the client, received an indictment, waive formal reading, and plea of not guilty, reserving pretrial motions.
Yes, Your Honor.
There will be signed reciprocal discovery orders for both of you, requiring the Commonwealth to give Mr. Cross the information they have available to help prepare for your defense. You should be here on September the 18th.
Your Honor, may I interject? I've been handed the Commonwealth's discovery, which indicates there's 298 files. This involves alleged improper use of a credit card. What we will need to do is, first of all, review what the Commonwealth.
You won't push the negotiation out, what you're saying?
Yes, I want to move everything out, probably until November.
Well, I don't know how long, when will discovery be complied with?
What day?
It's already been.
It's already been submitted. Mr. Cross.
It's quite late.
No, actually, you got it on entry of its occurrence, so you had it about a week.
By a week.
Okay, well, let's come back and take a look at this thing on the 24th.
Of September. They need
September.
to be here on the 20th. Okay.
If you want to go to, if you have enough information to go to negotiation, you can, but there's such a voluminous thing, I can understand not ordering. you to be there.
Well, I'm gonna have an October date yet. We'll have an October date when we come back.
Yeah.
Thank you.
Okay. Amy Lowe's. Amy Lowe's, look like an active worn out. Mr. Stockton.
Yes, we'll put her in CI.
Malone,
Same for.
Hennisha, Malone, William McIntyre. Are you William McIntyre?
Yes, sir.
Good morning. You're here on 26CR0040. Mr. McIntyre is your year of birth 2005. Last four digits through social security number 6774.
Yes, sir.
You're represented by Mr. Cross. You're here at a pre-trial conference. What does the Commonwealth have to say?
We need one more pre-trial conference. You're not unable to attend the last one.
Negotiation day is on the 18th at 9 a.m. and the next pre-trial appearance at 24th. And both of them are conditioned to your bond. You stay released on your same bond, okay?
Your Honor, he's got an ankle monitor. I would inquire if that could be.
What's his charge?
13, 14 counts of one and nine, but keep the firearm. In the.
And we'll just keep it on there if you
Okay.
don't mind. Thank
Wait
you.
for me outside. Your Honor, I'm back on Pickford. There's a bond condition I was going to ask the court to remove regarding their ability to bail.
Hold on just a second. Hello? 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 Okay, go ahead. If it's a-
Your Honor, the Pickards, apparently neither one of them have any record whatsoever. They live over around Persimmon. Their kids go to Monroe County Schools.
What is the limitation?
It's supposed to be just work, church, court. They've got 6 kids. They're in a lot of activities. And
Okay,
I would agree with Lifty that, as long as they don't have any contact.
well, no, we'll let them go with any school-related activities or anything that deliver their children wherever they need to go.
Thank you.
Okay,
Okay.
change that.
I think that's all I have, Your Honor.
Yeah, have a blessed day. Jackie Powell. What's the story on Jackie Powell? This is David Steele represents Jackie Powell.
See you, Dan. Or if there's a file here. Or if I know that nothing's getting hold of that. No, no, really.
But you know,
Now, let me see if I can contact Mr. Steve. Give me a pretty good state of contact.
So then just not like here's the. And then ask.
But we got a plea on that. Yeah, I think it's Jason stop. You know, you're supposed to be in court this month. Well, I think my secretary and all this communicated, she said we continue the negotiation day, not court day.
Let me put you on speakerphone here with the judge. Yeah, I've got Mr. Steele on, Your Honor.
okay,
Your Honor, I misunderstood Mr. Stockton's secretary, Judge. I apologize, sir.
okay, well,
He thought that he was excused from court and the negotiation day, and we just meant the negotiation day, so there's a miscommunication.
okay.
Judge, we received an offer that Mr. Powell was going to accept.
Okay,
It's a
September, be
$530.
here on September the 24th. Have your client with you.
I absolutely will, Judge, and please accept my
No
apology
problem, no
first. I
problem.
made a mistake.
I made a mistake once, I mean, like 1998 sometime. Okay, have a great day.
Jesse, I apologize.
Commonwealth versus Frederick Robinson. Commonwealth versus Frederick Robinson, 26 CI 0033. Mr., are you Frederick Robinson?
Yes.
Good morning. Were you born in 1973?
Yes,
Last 4 digits, social security number 0103.
yes.
We're here for pretrial conference. What do we have?
We have a plea for the court to consider.
A felony plea?
Yes, sir.
Okay. Sir, I understand that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 26 CI 00033?
Yes.
Is your judgment impaired today in any way? Okay, have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you, believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights. Before I can accept a plea of guilty, I need to know that you fully understand those rights.
Yes.
Okay, I'm gonna go over them, and if you have any questions, step away from the podium and ask your attorney, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speak at trial by jury. You have to be represented by counsel at a jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, a right to call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and right to part of the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by any guilty plea today, you give up those rights. You understand that?
Yes.
And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it prior to accepting any recommendation or a pre-sentence investigation report to be done by probation and parole. In the event that I don't accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea guilty and proceed to trial. Do you understand that?
Yes.
What is the Commonwealth's recommendation, Mr. Hunt?
Your Honor, upon a plea of guilty to unlawful transaction with a minor in the second degree, the defendant shall receive a sentence of 10 years. He shall serve 6 months. The balance shall be probated for 5 years. Probation is to be supervised. The defendant agrees and shall have no contact with the victim. The defendant shall pay court costs at the discretion of the court. He agrees to obtain employment or do 30 hours a week community service. And any drug paraphernalia or contraband involved in this case shall be disposed of.
What are the facts of the situation?
I do not know.
Your Honor, Mr. Robinson was having telephonic communication, I believe, with one of the Dollar Springs. And I ain't gonna go into the details of it, but there was some solicitation and some flirting back and forth, and that's the reason for the reduction. Yeah, she's 16, 17 years old, it's not a small child. Communication.
Were there drugs involved?
No.
No drugs involved.
My understanding of wrongful transaction in second degree is being.
Right. We need to do 2 counts, reduce it for the court, object, that's reduced to 5.
What, you had 10 years on? Tell me something about this.
Well, it's hard to go in detail unless I will show you the next, it's reading verbatim.
He was sending
He was communicating,
vulgar, solicitous.
not vulgar, that I think there was some flirtation on her part. He asked some things he probably shouldn't have, that he wanted her to do. But it didn't ever progress. Vulgar, sexual, I think, more nude.
More what?
Nude.
And did she do those things? Has he got a record of some sort?
Not that I,
Would this make him be on the register or anything?
no, it will not. That's one of the I mean.
Well, Judge, we're gonna ask the court to go along with it. I mean, we negotiated this case heavily with the Commonwealth and we had concerns and I think they shared some of the concerns with us and that's how we.
Well, it doesn't bother me to reduce it to 5 years. You know. I don't guess you'd be doing that again, would you?
No,
Yeah, I mean, that's about right, yeah.
yeah, it was, I was.
You the officer involved?
No, sir. No, Robert Dyer. He was school resource officer.
Yeah. Okay, is that your understanding of Commonwealth's recommendation now? And he's gonna have to serve how much?
He's gonna have to serve 6 months. He's got 2 months in, so he's gonna serve 4 months.
Okay,
Serve 4
are you
months.
pleading guilty because you did commit these acts charged in the indictment?
Yes.
You do so your own free will. And your constitutional rights explained to us 2 years out to proceed with the plea and allow the court to fix your punishment.
Yes.
You understand that now this is a felony plea. You understand that after this plea, that could be used against you in the future if you have another felony. You understand that?
Yes.
Is that your signature on the document?
Yes.
Okay, I'll accept the agreement, order pre-sentence investigation report and schedule sentencing on September 24th. You're in the custody of the jail.
Still think there's.
Jordan Scott. Jordan Scott, Commonwealth versus Jordan Scott. 26 CI 0036. Are you Jordan Scott?
Yes, sir.
Good morning. You were born in 2002.
Yes,
The last four digits, social security number 3365.
Yes, sir.
You're here on a pretrial conference. What do we have?
Judge, we've got a pretrial version plea for the court to consider.
I understand that you wish to enter a plea today. Is that right, sir?
Yes,
Sir Scott, are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that we just named in 26 CR 0036, correct?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Are you satisfied with the advice of your attorney?
Yes, sir.
You reviewed the evidence the Commonwealth has against you, you feel like you're fully informed about your case.
Yes, sir.
You understand that you do not have to plead guilty today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you fully understand those rights. I'm going to go over them. Anytime you have any question, you can step away from the podium and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, the jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. You have the right to produce evidence. Right to call witnesses in your favor, the right to appeal this matter to higher court. The right to require the Commonwealth to be on a reasonable doubt that you're guilty charged against you. Understand that by entering a plea of guilty, you give up those rights. You understand that?
Yes, sir.
Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In the event I don't accept the recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and go to trial. I'm going to ask some qualifying questions here. Have you previously been diverted in the last 5 years?
No, sir.
Have any felonies in the last 10 years?
No, sir.
Are you on probation now?
No, sir.
Okay, you understand if you successfully complete the diversion program, the charge will be dismissed pre-trial diverted. And you can have your record expunged, okay?
Yes, sir.
But if you do not successfully complete the pretrial diversion, you will be brought back in front of the court. If I revoke your pretrial diversion and sentence you, you'll be a convicted felon. That could be used against you in the future. You understand that?
Yes, sir.
Mr. Hunley, would you go over what the recommendation is?
Upon a plea of guilty to strangulation second degree, defendant shall receive a sentence of 5 years, pretrial diverted for 5 years, with the diversion to be supervised. The defendant agrees, and I would think it would be the order, and that the court demands that he complete anger management classes. The defendant agrees to have no contact with the victim, Alyssa Doney. He shall pay court costs at the discretion of the court.
Was the victim okay with this?
Yes.
Okay. What's the court cost? What? 220. Okay, you need some time to pay the $220. You need some time to pay the $220. Take some time. I'll give you some time to pay the $220. Okay.
Yes, sir.
You pay it $40 a month. You can pay it off if you want to. You can pay it $40 a month, the first payment 30 days from today. What's the deal on it? It wasn't any time to serve. It's pre-trial diversion. Okay. Okay, well, it's a diversion. You need to meet with a probation parole officer back there, okay? Commonwealth versus Cody Stinson is to be dismissed. He's deceased. Commonwealth versus David Terry. David Terry is not here.
Now he is done.
Does that complete the docket? So anyone else, anybody else here? We got a volunteer here.
I'm on the docket for about a week, so I didn't know if I needed to be back on.
We submitted orders on all those, but this needs to burn.
Okay, what's your name?
My name's.
Go forth, be happy.
Okay.
Where are these gnats coming from? See these gnats? Okay, is that it? The criminal docket?
Yes.
We got a late start but an early finish. We go off the record. We'll be back on, we have a uh, have a document for us. So we don't have anything else. She'll pause it all. Okay, the diversion docket.
Good job.
Hey, Brian, that's a good thing. Let's forward. Go forward. Okay. This different all cheap. We won't fill each other. Hey, big guy, we got four. That's it. Appreciate it. All right. Where's he at? Just want to let you know, we got four waiters. Hurry it up. Yes, sir. Looks that way. No. I'll see.
Back a little bit.
No, it's.
His mom's gonna go.
We'll just have a question.
Pretty funny, real quick. I am like, I'm all right. I said, looks that way.
You may have a seat. Thank you so much. Ah. It's up there. West Bend Mutual Insurance Company versus Fletcher. We had one child. Well, let me do this one child support case here first. Y'all go ahead and have a seat there at the table if you want to. Bryant versus Bryant. It's 14 CI 005, Bryant versus Bryant. What do you have here?
I had received that we were
You're
coming.
gonna have to speak up a little bit.
I'm sorry. Ryan had requested for his child support to be recalculated and to be reduced. And I wasn't in agreement with it, but. Aware. He had filed a motion.
I talked to Mr. Hurd a few minutes ago.
I wasn't in agreement with it. It went against what we had originally agreed upon in our divorce papers. It was a private and it was to not seek reduction, and that's what he's asking to do. And I have those papers if you need them. And it's current.
Wait just a second. I don't see motions or anything in here. This is just a notice of filing here. What is it? Yeah, but this is a notice of filing. It just says come up right there. Files. I mean, there's nobody representing Mr. Bryant. There's nobody representing her. There's no motion here. And speak up a little bit so I can hear you. I'm having trouble.
Okay.
Okay.
I was told about the motion that he's seeking reduction.
Who told you about it?
The child support office. Because I had been in contact with them because his child support is currently, it's behind since June.
Okay.
And then he had filed a motion to have it recalculated.
See, I don't see that motion here. It just says comes to Commonwealth and files the Kentucky Support Guideline worksheet that was calculated upon petitioner's request for modification review. But, it appears to me that Mr. Bryant has got to file a motion for a reduction, and he's not here today.
Mm-hmm.
So I'm just going to pass over this.
Okay, so do I need to do anything right now?
Well, you don't need to, I can't give legal advice. I could switch hats here real quick, give legal advice, but nothing's gonna change today. So if he wants a reduction in child support, the county attorney is out of town today, and he called me earlier and told me that they had done the calculation, but the calculation in and of itself would appear to me that you might need to lawyer up at some juncture if Mr. Bryant, I'm gonna say he needs to come in and explain this. I don't know, I'm not gonna do anything on
Okay.
it today,
All
okay?
right, thank you.
So it doesn't affect your payments, right? You're still entitled to the previous order, okay?
So he should still be paying currently where he's
Well, I
behind?
mean, whatever the order says.
Okay,
If the order, whatever order says is what he should be doing unless it's been modified, okay?
okay, all right, thank
Okay,
you.
thank you, yeah. Okay, West Bend Mutual Insurance Company versus Fletcher Excavation.
Good afternoon, Your Honor. Robert Joyce for the Fletchers.
Okay,
Zachary Russell.
you need to speak up, okay?
Yeah, Zachary Russell for West Bend Mutual.
Yeah, go ahead.
Your Honor, there's the plaintiff's motion for costs and my client's motion to alter, amend, or vacate. As filed, I understand that the court is very frustrated that this case has gone
You
on.
don't even understand. You might think you understand, but you don't even
I
understand.
probably don't, Your Honor. Hopefully in the motion, there were enough questions and facts raised that had they had the opportunity to be able to respond timely, that it would have been enough to survive summary judgment and move this case toward ultimately a trial. And so they're asking because
I don't really understand what you're saying. Say it again.
in the motion, Your Honor, there were five or six.
The portion that I don't understand is saying if they were given the opportunity to respond, why weren't they given an opportunity to respond?
They didn't hire me until after their
So
time.
that's not your problem.
Yes, Your Honor.
It's their problem. I dealt with them for months and trips and tried to get them to hire somebody to respond and gave them every opportunity to respond. And they never came up with any documentation. What do you have to say?
I mean, honestly, we did give them quite a bit of time to respond.
I can't hear you, man.
Okay, sorry. We gave them quite a bit of time to respond. I mean, we filed the motion for summary judgment back in February. And then we got an original hearing that was scheduled for March 24th.
Man,
And then we got the preliminary response.
who's this standing up here?
Oh, I'm sorry, I'm just gonna give this to Holly.
Okay, I thought you were asking to
No,
be
I'm sorry.
recognized here. I didn't know. Go ahead.
So we got the preliminary response before that initial hearing date. And in the interim, the defendant's counsel ended up withdrawing, and then they tried to represent themselves per se. And then now they have new counsel. And finally, we got that motion for summary judgment to be granted in the end. So.
I'm not gonna do anything on this case. I might be wrong on the case, but the Court of Appeals is gonna have to tell me I'm wrong. I just am completely frustrated with the case. There were some issues that I thought were interesting, and that was whether the bonding company had any obligation to pay a vendor whose lien claims might have been barred by the statute of limitations, but I never got enough information about that, couldn't get it up, and the only thing I ruled on was what was in the record. And so also, there wasn't ever, I didn't think that West Bend was ever given very much proof as to these payments that the Fletcher said that they were entitled to, that there wasn't an offset over. Did you ever get anything on that offset sort of information?
that
Do you know?
No.
You're just coming here to cover it today, correct?
Yeah.
Thank you.
And that's my argument, Your Honor, as to why they would ask that the court to be satisfied.
I'm not going to do anything on this. I've had all of this I want. They were given every opportunity to come forward and place a defense. If I'm wrong, the Court of Appeals can tell me I'm wrong and we'll come back and try it. But I'm not going to spend the rest of my life going through here and trying to get people an opportunity to defend themselves when they will not stand up. I wish they'd hired you early on. We could have avoided all this maybe, but so I'm going to respectfully deny your motion to alter, amend, or vacate, and that'll be a final and appealable order, and go up from there, okay?
Thank you very much. Your
Thank you very much.
That's all the business I have.
Yeah, you have a safe journey.
Thank you.
Thank you, Your Honor.
Yeah. Brewington versus Brewington.
Afternoon, Your Honor.
Hello, everyone. Okay, I read the motion and I can't really tell what I'm here for today.
Just for set a final hearing date.
On what? On what?
On the remaining contested.
Well, I know, but you say the remaining ones. I don't know what the remaining ones are.
Would be custody and parental time sharing. Also.
Is that it? All the other stuff's been held?
The property aspects have been handled. The only other thing is that the outstanding issue was whether the child was going to attend public school. The last time we were here, the court indicated that we should get a psychological evaluation of some sort. I found out what the cost of that was going to be, shared it with the parties, never heard anything back from anyone. My client's of the opinion it's a lot of money for a single issue about whether to go to school or not. I don't know what the other.
That's what some people say about the cost of surgery. The guy said the incisions cost $100. Said, what's the bill? The rest of it about knowing where to cut, you know?
But no one was forthcoming about, well, we're gonna ready to pay our half to go do it.
So you got the private versus public school and then timeshare.
Share, yes.
You're
And
not
of
gonna be
course-
able to agree on that?
We cannot judge because of some ongoing issues in Mr. Burlington's home that we believe are.
I can't hear you.
I said not because we believe there's some ongoing issues in Mr. Brewing's home that would affect the timeshare for the equal presumption.
Your Honor, in regard to that, the parties have had joint custody for well over a year. There's been no communication from her about these ongoing problems, or they would have been corrected by now. And we don't even know what they are. So.
What are the ongoing problems?
Well, Judge, we've made him aware of those throughout the
Make
course
me
of
aware
this.
of them. I'm the one that needs to be aware of.
He's given the minor children alcohol. We have concerns that there's substance abuse going on in the home. The way he's conducting himself with the children and trying to alienate my client. So, I mean, we've addressed those issues since the beginning in this case.
Well, I thought some of them might have been resolved.
I don't think they have. I think some of them may have actually gotten worse, Your Honor.
My client has not received any communication from the other parent about these issues.
Well, I mean, you know what they are now.
I do now,
Okay.
yes.
And the other issue was the timeshare in the school. How many children are involved here?
There are 3 children, but one is aged out and now in college. So we have 2 children, one that's in the 5th grade, and then we have one that's 16 years old. Is in its junior year.
Who's going to go
It's a senior
to,
year.
which one's going to private school?
Well, both of the children that are underage are still being homeschooled through the Panther Virtual Academy, with my client being very involved, and that's what they did throughout the course of their marriage. And the oldest child graduated through the homeschool
What's the
program.
issue?
There's no issue as to the older child who's 16.
Well, what's the issue then?
The only issue is the youngest child. We would want 50-50 cuts.
I'm talking about education right now.
The child wants to go to the public school system, and he wants her to have the opportunity to do that.
How old is the child?
She's just started 5th grade, Judge.
10, she's 10.
10 years old. And she expressed to the mother that she wants to go to public school too?
Not to the extreme. What she's expressed is things that my client and his girlfriend have told her about the school system and the girlfriend's children going.
Or she's expressed many times that she wants to try it.
We're not gonna take testimony here today, will. Okay, you got your calendars out? How many witnesses you think you're gonna have?
I would think we would probably need half a day because
How many witnesses you got?
I'm gonna have at least 3.
You?
No more than 3, Your Honor, and I'd say we need 2 hours for our testimony. I think they need 2 hours for theirs.
And the judge, my client has made me aware that some of the terms of the mediation agreement of things that Mr. Brewington were supposed to do have not been fulfilled. So we'll also be filing a contempt motion asking the court to address those issues during the hearing as well.
That's fine.
What about next Thursday?
September the third.
That's correct.
I've got court in Russell County. And I have hearings on, well, I've got court with you on the 10th and then hearings on the 17th and the 24th. I'm back here with you on the motion day, so I don't have anything open until probably the second week of October.
Well, we're gonna hear something on this sometime. You have to make room in September. I'm not gonna let this tarry along as far as where the school's starting now. If I make a decision that the child goes to public school, it would be unfair to drop the child in after 3 weeks of school.
I understand that, Judge, but they've not pushed this issue and she went all through school last year.
I'm just telling you what I'm gonna do, okay? Let's work together on this and find a date.
Do the afternoon of the 18th.
September 18th is fine.
No, I'm not gonna do a Friday on this thing. How about the 15th?
I have court in Russell and Wayne County, Your Honor.
I have,
Several cases.
I
So
also
I might
have
be
court
free that
there.
afternoon.
I have court in Adair County. That's our rule day.
Did you say that like next Tuesday, you have some, y'all, or y'all on the first?
I have court in Taylor County. And then I've got
All
court,
day? What,
then I've got court in Barron County that afternoon.
September the first. You can't do it. Doesn't matter.
what about August, what about next Monday afternoon?
31st.
I'll have to make sure I don't have any juvenile court. If I can move my juvenile cases around, I could do the afternoon, and move some other
Let's
things
be
around.
here at, on the 31st at, 2:00. And we'll stay as long as we need to.
We need to set up.
Okay, thank y'all very much.
Thank you, Your Honor. That's all I have here.
Oh, Turk Parish versus Shawhan.
This was our motion to review, Judge. The appellate matter has been
Let's see,
resolved.
okay. You probably remember all the cases that you have.
Yes.
I couldn't tell from your motion what we're here for today.
Oh,
Would you kind of, when you do these, would you kind of feather them out a little bit so I don't spend my time digging through the file to figure out what you might or might not be talking to? Okay, can we do that in the
Yes,
future?
sir.
So just tell me what we're talking about. Are you the guardian ad litem in the case or?
No, Judge, I represent Tucker Parrish. He's the petitioner and biological father.
Okay, now what's the issue that we're here today on?
We had previously filed a motion to modify and you had waited to rule on that based on Mr. Parrish's relapse concerning drug use. He was convicted of a drug trafficking offense as well as a DUI. And on my client's own improved circumstance regarding employment and housing.
What's the Court of Appeals?
We had appealed the original custody order from December of 2024. The Court of Appeals upheld your prior order.
Judge, I only received Ms. Atkins' affidavit last night. I have not had adequate time to review the document. She's making several claims in there. However, I can state for the court, Ms. Shawhan has had 176 visits scheduled since the entry of the order in December of 2024, and she has missed approximately 122 of those visits, which is roughly 71% of her time sharing.
Sounds like we need to have a hearing on this.
Yes, Judge.
And then, Judge, I had also filed a motion to intervene on behalf of the paternal grandmother, Sherry Purdue, last year that was held in abeyance until the Court of Appeals opinion came out as well. Just for the record, I know, did you get that at all on the record? Okay. All right.
And what about Tucker Parish?
Judge, he is at training for a new job. That's why he is not here today. This training was scheduled prior to the Court of Appeals releasing their opinion and the review date that was set today. We didn't know if today would happen with the Court of Appeals.
Previous judgment gave him custody.
The parties had joint custody. He was primary residential.
I believe Ms. Shawhan was receiving roughly 8 hours a week, 2 days, 4-hour increments.
A 6-hour and a 2-hour.
And what does she want?
She is hoping to work on increasing to equal time. We understand that not wanting to disrupt the children's schedules, that may need to be over a graduated period, but she would like an increase at least to weekends at this point. And we would be open to potential mediation with Mr. Parrish.
And of course, my motion to intervene is based on just to be concise, Tucker Parrish has had his own issues. He lives in the home with my client and the children.
In the basement, what is it?
Yes,
Pays rent.
and pays rent. And then my client is also very involved. She has to do the exchanges and the communication with Ms. Shawhan because of the problems between her and Mr. Parrish. So my client has been an integral part of these children's lives throughout. Ms. Shawhan has also been in jail twice since the entry of this order for harassing the Purdue Parish family.
It was an issue that had began prior to this court order. And the primary issue in communication is between Ms. Purdue and Ms. Shawhan. Ms. Shawhan would much prefer to communicate with Mr. Parrish. He has refused to come
I'd
here.
much prefer these people all
Yes,
communicate with each other reasonably and not come down here all the time. That's what I would, but so we all don't get what we prefer. What's the immediate relief that you want?
An increase to weekends.
You know, obviously y'all aren't for that at this juncture.
Judge, we are opposed to that. I think some of the same issues from me reviewing the previous record and the Court of Appeals opinion, those issues are still ongoing.
We can provide proof of stable housing, which was.
No, we'll have to provide proof.
Yes.
You know.
We have the
But,
lease today.
What has changed? I mean, this is pretty immediate. This other order is not that old. So has there been a substantial change in circumstance necessary to reopen this thing at this juncture?
Yes, Judge, we believe Mr. Parrish has suffered a serious relapse in his situation.
Well, I mean, yeah, but what about your client?
Yes, she is now in independent housing, not relying on familiar support. She is employed full-time.
Where does she work?
I work at the junction station and I start Amazon on September 9th.
But Judge, I guess my question would be, how long has she been employed at that job? Because that's been an issue.
And Judge, just from a quick skimming of the affidavit that I only received this morning, it says she's only had stable housing for 6 months, possibly less. She has been at.
Okay, well, okay, all right. Unless I'm gonna swear y'all in and let you testify, we're not accomplishing anything right now at this thing. Get your calendars out. We can't do it on any Wednesdays because we've got a trial every Wednesday for the next month in Monroe County. Did we look at the 21st when we were looking at your calendar previously, Ms. Capps? Yes.
Are we looking at the afternoon, Judge? I have court that morning, but I could do it the
You what?
afternoon.
Judge is still up, Mr. Carlson.
Okay.
Probably not the afternoon. I don't know, it just depends on what she is.
District Court trials that day. What kind of trials they got that day? They hardly ever go over into the afternoon.
Several criminal trials. Mr. Cross has one, Poindexter has two, DPA has four scheduled.
Okay, well, surely one of those will go, so.
Judge, do you have September the 29th open?
No, I'm gone. That's the only week of the year I'm gone. I'm gone that week. What do y'all have going on? Did you have something on the 3rd, next Thursday?
I have another hearing, Judge.
Well, I got Russell County.
Where is your hearing at?
Pulaski,
Is it the morning or the afternoon?
morning.
What about the afternoon of the 3rd?
If we started at 2, I could probably do that.
Start at 2. Your intervention is predicated on grandparent visitation, or how you establish your standing?
Well, at that point, I think, yes, it's predicated on the involvement and the
I
visitation.
know, but I'm
And then we
talking,
also,
what's the theory that you're intervening under?
well, we were filing to intervene because we'd also asked for a motion for temporary custody because of the things that were going on with the parents at the time.
As a grandparent?
As a grandparent, yes.
So I'll allow you to intervene. But you need to, when you file your motions and serve them quick, you need to understand and put in there essentially how you're gonna get standing. You know, that'll be something I'll have to decide first. I'm not saying that you don't have standing or that you won't have standing, but I think they need to be put on notice of why you're claiming standing. So we'll do that on the 3rd, 2:00. If any of you have anything that opens up that we could start at 1, if you'd be courteous enough to notify, I'll be available at 1.
I'm also available one, Judge.
You'd be available at 1, and you could possibly be available
Yes.
at 1 because you pick up an hour when you come back over here. So if
I'll do my best to
do
get
the
done.
best. So y'all be on standing to start at 1 if we can, okay? Thank y'all very much. Yeah. Okay. Whitlow versus Whitlow. Yeah. Hello, what's your name?
Sierra Whitlow.
Did you file this motion yourself or who?
Yes.
Okay, who helped you prepare it?
I used online to do it.
What online did you use to do it? What
Well, I wrote it out myself and then I had it, went in there to Word to make it professional.
AI? Did AI or what did you use? I'm just asking you what,
Microsoft Word to do it on.
do what?
Microsoft Word.
Microsoft?
Yes.
Word. Well, y'all were only married less than 3 years, weren't you?
Yes, sir.
So Mr. Whitlow is on it. What do you want from Mr. Whitlow?
Just like to hash the debt and I'm just ready to get divorced and have it over with.
Okay, you got debt listed. Can you hear what's going on, Mr. Whitlow?
Yes, sir.
Okay, now, the debt that's listed here is to Midland Credit for $785, total of $1,933. But then you got total marital debt. There was a deficiency on the car too, right?
Yes, sir.
So total marital debt, $6,826. So what you want to do is divide that debt with him?
Yeah.
Well, I mean, I don't want to put words in your mouth. You tell me what you want. Other than blood on your hands.
That part. But anyways, I don't know. I mean, if he could pay it all, I wouldn't care, but if he can't, I have it down the middle.
Are you willing to divide the debt with her, Mr. Whitlow?
Yes, sir. I'm willing to split it in half and pay my half.
Does that satisfy you?
Yes.
Okay, I'll draw an order up to that effect. And I want you to know that either one of you that don't do it could be subject to. Can you do it in 30 days? Pay it in 30 days, each one of you?
Mr. Williams, under my understanding, I'm pretty sure all those accounts are all charged offs right now. As far as I don't think the debt has pretty much went to a debt agency. So I don't know if that changes anything on as far as how long we have to pay the debt.
Well, I mean, if the debt is not paid and it's written to bad debt, it affects both of your credit rating. It might, you might.
That's what I'm worried about.
Right, I understand that. Yeah, I'm on board with getting both of our credit back correctly and
What kind of time? What kind of time frame are y'all gonna need to pay this?
I'm thinking, I mean, for that amount, I'm thinking, I mean, if I could have 6 months, I could definitely have the 3,000 or my half paid by then. But it just seems like a substantial amount of money to come up with in a week or a month.
I didn't say a week or a month. Let's say 90 days. Okay,
That'll work.
I'm gonna draw an order up and I want y'all to have half your debt and we'll establish the amount. At $6,826, but there could be some interest that is accumulated. If I were gonna do it, I think I would get somebody to contact the people that own the debt to see if they'll take a reduced amount.
Yeah, that's correct, Your Honor. I believe they will, because I've been sent emails and stuff regarding the accounts and giving me different options of ways to pay it.
Let me order y'all to have it taken care of in 60 days, okay? And I would suggest that there are a couple, 3 or 4 lawyers around the square here that you might go to that might enter into the thing and help you negotiate the amount down. And I mean, it doesn't, I'm sure y'all don't feel great about each other, but surely you can work together enough to save you both some money.
Yes, sir.
You know what I mean?
Yes,
So
sir.
they're the local attorneys here. I mean, you got Coleman Hurd has an office on the square here. Miss Perigin has an office on the square here. Lenny Judd has an office on the square here, and there are lawyers in surrounding towns. I suggest when we finish here today, that y'all have each other's phone numbers or anything?
Your Honor, we have had zero contact for the 3 years that we've been separated, so we have no way to contact each other, and we just kept it that way.
Well, that's good. I don't want to encourage any contact that might, like that. I'll just let y'all decide what you want to do about it. You get 60 days to pay the thing off and but you're not going to be able to separately negotiate the thing.
Right. I don't mind. I mean, whatever I have to do, I'll get it done within that 90 days. And then, I mean, I'd rather just let this go as quick as possible rather than fight it or.
Let me ask, would you like to contact an attorney to negotiate it down? And when you get it negotiated down, the attorney can contact, Mr. Whitlow, okay?
Yes, sir.
Does that work, Mr. Whitlow?
Sounds good to me.
Okay, thank y'all very much.
Thank you.
Tax Break Kentucky versus Larry Murray. The heirs of Larry Murray, I guess. Hello.
My
Y'all
name is Stacy Murray. My name is Alicia Coomer, and we are appearing pro se. We have a tax break versus Larry Murray.
yeah.
We are the children, and he is our deceased father. We have formally filed a response with the court that there is no estate in this case, and also we have no legal interest. Nothing was actually left to us, and we have relinquished any right to the property.
Is the real estate involved?
Yes, Your Honor.
And did the real estate go to you? Y'all the only 2 children Larry had? I knew Larry very well, the only 2 children he had. Okay.
Yes.
Okay, well, is anybody here for tax break?
Your Honor, if I may, we actually have prepared a notice of disclaimer and motion to dismiss.
Well, I don't know what you're disclaiming here. They've got a judgment. They bought the tax bill, right?
Yes. Yes, Your Honor. What we were disclaiming was that we had no legal interest. We were wanting to relinquish all rights to 811 North Main.
Well, here's the way it works, okay? I'll sign there's no such thing as a deficiency judgment. So if it doesn't bring enough, you're not responsible. Okay? So what we'll do is I'll sign the judgment and order of sale. The master commissioner's here. Commissioner, will you come around? I'll sign the judgment and order of sale. And at that juncture, the property will sell. And if the property brings enough to pay this off and there aren't any other lien, it doesn't appear to be any other lien holders, then the property will sell and whatever's left from the property will be transferred to you. So I don't think that, I mean, there's a possibility that you get some money, so you don't need to
Okay.
disclaim anything here unless you just feel very charitable at this time.
So, Your Honor, I think the concern was that it looked like the judgment was coming against us and we were gonna be
It's not gonna
personally
be that. They
liable.
just named you as people who own the property now. That's the only reason.
Okay.
And you are not Robbie Murray's grandchildren if you give money away that easily.
The fees were excessive.
Well, I will review the fees, before we do the judgment, but I will tell you that I agree with you that, fees appear to be excessive, but the General Assembly passed this law that allow, and I deal with it every day. And people started cottage industries where they just go out and buy these tax bills of $300 or $400, $500, and then you got $7,000 or $8,000.
Yeah.
That seems excessive. I agree. Have you looked at the proposed judgment in this case?
Judge, I don't think I've received it in this case.
Okay. Well, we'll review, I'll take a review of the proposed judgment here. We get the file here. I'll look in there and see if there's a. Yeah. Here it is, I got it right. Well, anything under $2,500 attorney's fees, they don't really have to do that. So they're asking $2,245 and pre-litigation costs of $1,800. That's probably warning order attorney's fees and stuff. You got the affidavit there? Oh. Well, I'm gonna take it under advisement. I've looked at that, some of these, I can't believe that it would take an hour and 20 minutes to review a 2-page complaint.
You're a judge.
So I want you to look at that for me, okay? In the affidavit, and I will enter a judgment, but there can't be deficiency judgment. So I'll enter the judgment, we'll take a look at their costs, enter a ruling on it, okay? Okay.
Thank you, Your Honor.
Yeah. Okay, Delcy Howe. versus Connie Lou Cooper, Courtney Willis, and Chris Shekels. Okay, what do we have here?
Your Honor, that's my motion for a final hearing on all the remaining issues. Remember last time we were in court?
I don't remember actually.
Several months back. It's been several months since everything we've done, and we just need to wrap up whatever remaining issues.
Well, what are the remaining issues?
The most important thing is probably gonna be the temporary sharing of the children and stuff. If you recall, Miss Powell was in a relationship with Miss Miss Powell's son was in a relationship with Miss Cooper. And they had lived together for a little while, and there were some kids involved. She ended up with custody of both of the kids.
Who's she?
Miss Cooper, Your Honor.
Yeah.
And the court gave temporary visitation rights to the grandmother. I'm not sure how that's gone. I don't think it's gone particularly bad, but we need to get some permits and get everything.
Well, what do you want though? I mean, tell me what relief. Are y'all getting to visit the children now?
Yes,
Is that working out all right?
working out fine.
And
Nobody
is
is
it working
working.
out all right for you? Okay, what are
I
we
want to
here
get a
for?
final permanent ruling, Your Honor.
Well, I know, but I mean, what do you want the ruling to be?
Well, I just want some permanency, Your Honor, because.
Well, tell me, I know you do, and I'm gonna give that to you, but you need to tell me what you want to be in the order.
Her with sole custody of the kids and no visitation, Your Honor.
Well, I thought she said the visitation was going okay.
She did, but you asked me what I wanted. You didn't ask
Why
me
would
how
you
it was
want
going.
something that your client doesn't want? Your client says the visitation is going well.
But that's not what she wants. She said it's going
Okay,
well, but she's
okay.
not said that.
I'm not gonna.
Your Honor, I attempted to appeal your prior ruling on this because it was just a temporary order, and the court held that it was still not a final order, is why I couldn't appeal it, because one of the things was based on one of the children wasn't, I guess, eligible for that to happen, but the court still gave visitation rights to the grandma when really that was inappropriate and stuff. And what I'm actually seeking is for the court to do a final order so I can appeal the court's orders of what they did prior to this.
Well, you know, I've kind of always thought when you have attorneys and counselors at law that their role should be, and I try to do that as a judge, to try to give people an opportunity to reach agreements that are in the best interest of children and everybody. And when you tell me that you just want this order because it's gonna, you want to appeal something that your client doesn't indicate that she wants, it makes me wonder why we're here. But I'm gonna have a hearing. I'm gonna have a hearing on it. We'll have a hearing on it. And so she wants to deny these folks any visitation with the children.
Yes, Your Honor, and you can ask her that if you want to.
Is that
The
what you?
possibility, the least one. But the oldest one, she can go. But the youngest one, she ain't no kin to him. I mean, she ain't no blood.
Okay, so they're both my
Well,
babies.
well, I understand. What they're saying is that you don't have any standing, to have visitation.
That little Autumn is happy when she's.
Well, I know, but we're not talking about making a child happy, or we're not talking about what's in the best interest of the child, in your opinion. They're saying that you've got no legal right to have
No, I
visitation
don't.
to the youngest one. And
But, Autumn and Ruby are half sisters.
I understand that, but the younger one is no blood relative of yours. Is that correct?
That's correct. But
Okay.
she's not blood relative.
Yeah.
But Autumn, when they're there together, she looks up her big sister. She wants to
I
be right with her.
know, ma'am. It's not the issue about what would be their little half siblings and they love you and they have this relationship with you, but this lady does not want you to have visitation with the younger. Okay, that's correct?
Yeah.
Okay. Well, is that the only issue that you have with it, or do you want to do something about the older child too?
Well, we discussed both children, but I'm not sure if my client's changed their opinion or not. There are other issues, Your Honor, but in the interest of judicial economy, if you want me to go over them, I can go over them with you, but.
Well, let's just have a hearing.
Want to
Let's
go
just
over
have a
them?
hearing. You got your calendar with you?
I do.
Okay. And I scheduled earlier something for the 31st, but what was the other day that I had a partial hearing? Are you available on September the 3rd?
I've got something, but I can reschedule, Your Honor. I'll make it work whatever time the court wants me to be here.
Okay, let's be here on September 3rd at 10 a.m.
Thank you. I have nothing further for that.
Wait just a second, wait just a second.
Yeah.
Now, I would suggest between now and then, if y'all will check around and see if you can get a lawyer or something to come with
I'll
you.
call our previous lawyer,
Okay, who was your previous one?
Nick Carter.
Yeah. Well, why don't you call it and see if you can be here that day, okay? Thank you very much. Okay. Johns versus Johns. Now, this, a motion to resolve mediation agreement, so.
Yes,
So we have a mediation agreement and I'm supposed to determine what the mediation agreement means, correct?
that would be correct, Judge.
You are Michael Johns?
Yes, sir.
Okay, where is Pamela K. Johns?
Judge, Mr. Lawless here for Miss Johns.
Okay, good. Welcome.
Thank you, Your Honor.
Okay. I read this motion. It appears the disagreement is which source of funds the $128,000 comes out of. Is that correct?
Yes, Judge, that
Is that the only issue?
Yes.
Okay, what is, if it comes out of one fund, it's pre-tax and the other one it's not, is that the issue?
Essentially, yes, Judge.
Well, I know, I want.
And I also.
Luke Lawless, is that you?
Yes, Your Honor.
Okay, what's your problem with, tell me which fund you want to come out of and what your argument is.
Well, Judge, the mediation agreement that the party signed and that council signed on June 29th, and it was entered into the court record, Your Honor signed it electronically on July the 7th, has the agreement with the attachment A that cites specifically that the $128,000 is to be paid from the investment account within 30 days of the decree. The motion that was filed includes.
Well, I'm not doubting that, okay? I'm asking you, what's the difference between paying it from one account or the other? Is there a tax difference?
If the money is provided to my client through the 401k and then she withdraws it, then she's going to be subjected to taxes, which would not be the case if it was paid through the investment account, which is why we agreed to it.
The only thing I was asking.
Yes, Your Honor.
I assume from reading that was the problem. Now, what do you have to say about that?
Judge, our position is.
I can't hear you.
I apologize, Judge. Our position is Exhibit A was the final mediation agreement that the parties agreed upon. Exhibit B was presented to us first and we denied that agreement. And that is why Exhibit A was created with the 401k account. If that wasn't in controversy, we obviously wouldn't be here today. Mr. Johns will have issues with capital gains taxes.
Well, wait just a second. Okay, we got attachment A.
Correct.
And attachment A says shall give Pamela $128,000 from his 401k within 30 days.
Yes, Judge.
Okay, and then the next one says Michael should give him $128,000 from the investment account within 30 days.
Yes, Judge. And we were under.
Well, wait. Now, which one of these was the exhibit or the agreement?
Judge, we were under the impression that Exhibit A was the agreement that we were signing off on.
Well, I mean, what do you mean under the impression?
That this was the last agreement that was presented to us at mediation.
Well, I mean, are you on the record? Was the mediation recorded?
No, Judge, it was not. The parties had to be in separate rooms. And
Well, I mean, was there a signed mediation agreement?
There was a signed AOC form stating that we had reached a resolution and Ms. Hargis was going to reduce all that to writing to submit to the court. And then after she submitted it to the court, it appears that she put everything in Exhibit B, which was not the agreement that we, to the best of our knowledge, had agreed upon. We had agreed upon Exhibit A's documentation.
Why were there two different who did the attachments?
Kimberly Hargis in Adair County. So Ms. Hargis presented Exhibit B to us separately, and we denied the agreement and asked for her to go back and request the $128,000 to come from the 401k and not the investment account, which is how we come to have the Exhibit A document. We were under the impression that that offer was accepted.
She didn't come back and tell you which one they were going to be on there?
To the best of our knowledge.
No,
and
I
understanding.
just asked you not to, I mean, yes or no. Did she tell you that A was accepted instead of B?
Yes, yes.
Your Honor.
And where is it
where's
the form?
We've never seen it, the attachment A with the motion that has the handwritten additions. I'd never seen that document until this motion was filed. And the mediation agreement that was filed with the court, it shows the investment account. That's what we signed. That's what all the parties signed. And I don't know where this other attachment came from that mentions the 401k. Like I said, I'd never seen that until the motion was filed. So I have no idea where that came from. It was never presented to us that way. And we all signed off on the investment agreement, on the investment account. That's the only thing that me and my client ever saw. We all signed it and we left that day with this agreement in hand. And that's what the mediator, Ms. Hargis, filed.
Judge, she
And the
filed
court
that.
signed it.
I'm sorry, she filed the AOC form, which is the mediation agreement.
I see that with an exhibit.
Yes,
Okay, and the exhibit that's attached to it, Exhibit A, says the investment account.
That is correct. However, we had two competing documents. The way Ms. Hargis conducts is she will type all this up and go back and forth between.
Well, are you
those.
saying that the attachment was not assigned to it when your client signed it?
It was not attached to that document. We had both of these documents kind of floating in existence. We were under the impression Exhibit A was what we were signing off on. The after decree is my handwriting where I wrote to Ms. Hargis that I wanted, that was the only thing I wanted added, was that the 128,000 would be paid from the 401k 30 days after the entry of the decree.
I mean, this is a significant difference. What problems would it cause your client if it came out of the 401k?
If it comes out of the 401k?
Yeah, what problems? You say you want it to come out of the 401k?
Yes.
Correct.
That
okay.
would be the cheapest avenue.
Well, I know it would be because there hadn't been any tax paid on that. So if he
Correct.
transfers that to her, she's gonna have to pay the tax on it when she pulls it out.
That would be
Correct?
correct, Judge.
Okay, now, do you think that there's not a significant difference between those two situations? The investment account, if he pays it out of the investment account, he's gonna have to liquidate.
Yes, Judge, and he needs his investment account to stay at a certain threshold to keep his monthly income that was calculated in with this mediation agreement. If the investment account drops below the amount that is currently in there, he will no longer receive his monthly income.
How old are you?
72.
Well, next year you're gonna have to make required minimum distributions out of your investment account anyway.
Out of 401k.
Yeah, I mean, out of the 401k.
Yes, that's correct. And I know it's minimal.
Well, it's minimal until you start having to pay it. I can tell you that for sure. See.
The mediator said they should get their own deposit early.
Yeah, get the mediator on.
That's what we had. I think she's got it.
I just sent her bill.
Do what?
I just sent her billing.
Well, for both of you, I think it's great practice when you have an exhibit to something like that, for that to be initialed.
And Judge, I will also mention that's why the bottom of Exhibit A says pick up Tahoe on July 7th, because we were fleshing out those remaining details of when she was going to
Well, I
come
know, but
pick
that
up
doesn't
property.
mean that it was included in the agreement, because the agreement has the other provision, exhibit attached. I'm just saying, in the future, when you have any kind of document, that's the reason that people initial every page of a will, for example. Shows that they initial it, they execute it and initial it. Kimberly, could you turn your camera on? Are you with us, Kimberly?
I am, Judge.
Okay, we have in front of me here Michael Johns and Pamela Johns, who you did a mediation agreement for. The issue has arisen here that there were two attachment A's. And the one that was attached to your mediation agreement calls for a distribution of $128,000 from the investment account. And the other one calls from $128,000 from the 401k account. And obviously the tax status of that. Mr. Perigin says that they were under the belief that they were doing the Exhibit A with the 401k and in the situation. And Mr. Lawless says that the one from the investment account was the one that was attached to the mediation order. Do you have any recollection about that whatsoever?
Okay, I'll tell you what I remember, Judge. My understanding was we were back and forth and the money was going to be an issue, and Mr. Johns agreed if it could come from his 401k, he could get the money and get it transferred immediately. I feel like that was partly my fault and I should have made sure I had the right attachment. But it was a pretty long mediation that day. So, and we were back and forth a whole lot. We tried to go back and forth through email to try to get that took care of, and we could not. So I knew that they were filing a motion.
Okay, well, I'm going to set aside the mediation agreement. There appears that was not a real accord done, and we'll just have a start from the beginning on this thing, and we'll have a hearing on it. If y'all can't agree to this, so. Okay. Y'all want to have a trial on this thing as far as the property, or you want to go back to the table again?
Judge, can I have a moment to consult with my client?
Yeah.
Okay, just one moment, please. Judge, we would like to propose to keep everything in place as far as the mediation agreement and see if Mr. Wallace's client would be agreeable to half of the money coming from the 401k and the other half coming from the investment account. She will still get the agreed upon $128,000.
Well, she doesn't get the agreed $128,000 because there's a big difference between getting money out of 401k that would be subject to taxation. I don't know what her income situation is. It might be a de minimis amount of money that she'd have to pay taxes on if she doesn't pay very much taxes. She could draw it out when she wanted to and might not owe any tax on it. I don't know. But that's not the sort of thing that the council, I'm sure, has the authority to reach an agreement on today, Mr. Lawless. Wouldn't that be true? You're not in contact with your client.
That would be true. That would be true, Judge. And if we're going to have a trial on the matter, we're going to have probably appraisals done of the real property. We're going to be subject to selling the marital residence and things like that we haven't done because we did the mediation.
There's no doubt about it. You just go back to square one and that. Let me ask you something. Just as a point while we were talking about this, could you check with your client and see what sort of tax implications that she would have if she took half of it from the investment account, took the other half? How old is your client?
She's around the same age, Judge. Let me see her birth date here.
You draw it out without penalty, and she could draw it out without penalty. If she doesn't have to draw it out until she becomes 73, doesn't mean that she can't draw it out, and she might be able to draw it out periodically without any tax implications at all. You follow what I'm saying?
She'll be 74 in September.
I think the issue is that she needs a place to live. And so that's why she agreed to the way that she did, was she was going to need to buy a place to live. She's living in a commercial building currently because Mr. Johns kept the marital residence as a part of this agreement. So that was the initial reasoning that was told to me, but I'm happy to check with her, Judge, and see if she would be agreeable to this proposal.
And there are also, check with her on that, and there are also situations where you have distributions of 401ks or deferred comp plans, or where the money can be drawn out without penalty. But the tax situation is what I'd look at, and I'd see what sort of income situation she's going to be in. Was she going to spend all of it to buy a place, or will the amount of money she's drawing out from the investment account be enough for a down payment, and then she could draw the rest of it out without implications? So I would, not telling you what to do, but I think it's only fair for you to get some tax advice for her from an accountant or something, and we revisit this. So I'm gonna give y'all let's say 2 weeks to negotiate this back and forth. And then we won't wait for the next rule day to set a trial, but it's gonna take some discovery if you don't.
Judge, I think it would be beneficial to the parties.
Speak up a little bit.
To maybe go back to mediation and see if we can flesh out this agreement, as Ms.
Well, the only agreement is whether it's coming out of the 401k, and that doesn't take mediation to do that. He's gonna seek the advice of his, of an accountant to see what it's gonna cost her. It's just a matter of money. If he gets out of the investment account, she owes nothing on it. It's after-tax dollars.
Understand. Judge, the capital gains does come out first on the investment account.
Well, it depends on what form the investment account. If there's enough liquidity in the investment account, if you don't have to sell stocks, I don't know what's in there's all kinds of investment accounts. If it's all stock and he has to sell it, he could transfer the stock out and there wouldn't be any capital gains treatment. You could get the value of the stock and transfer it out, and there would be a basis. Those are all accounting questions.
I understand, Judge. It doesn't remedy the issue. I think that she wants the $128,000 available immediately. I think it's kind of the issue.
Well, she doesn't get the $128,000 if she takes it out of the 401k. She's gonna have to pay about 30% tax on it or something like that. If she takes it all in 1 year, as far as the 401k is concerned, she pays no tax on it if she gets an investment account, unless you say it's all in stock. Now, did you know it was all in stock, Mr. Lawless?
No, I didn't. I don't know how I'm not really sure the details of the investment account. But you're exactly right as to why she wanted it that way, because she needed it. You're exactly right, Judge.
Well, if the investment account is all in stock, okay, in order to pay the $128,000, if he had to sell the stock and hey, wait just a second here. I want your attorney to listen to me, okay? We straight on that? So that's another thing you need to look at. Y'all need to talk to each other to see what sort of asset the investment account is and whether there'd be a tax implication to liquidate it. Doesn't say anything about paying it in cash or stock or whatever. Follow what I'm saying? So it could be that if he has to transfer stock out of the investment account over there, and she'd have some kind of capital gain situation on it because we don't know what the basis is.